All right, let's talk about the potential bias in the COPA v. Wright case at this point from an actual legal perspective, not hyperbole or opinion. And I'm just going to present the facts for the public to kind of review and also the case law here behind it, and people can make up their own decision. Also, just an update here. So far, I think we had a big space yesterday. Casey helped host it for me, and we had 1,500 to 2,000 people already listened to it. It's pretty popular on her X account. And so, basically we talked about this and broke it down with a panel, and Scott 369BSV actually started a petition because of it. And it's a change.org petition where 260 something people have already signed the petition asking for the investigation and recusal of Judge Miller in the COPA v. Wright case. Now let me just kind of give a little perspective on this. Something like this is normally frivolous, okay? And I haven't really talked about it before, bias. It's just excuses for the most part, all right? So I want to just say that for the most part, you hear biased, those are excuses, and it's nonsense, okay? I've been there. I used to do that myself when I first started. I said, the judge is biased against me. He doesn't like me. That's just nonsense because you have nothing to support it. Now, this is much different. This is actually far different. We've got actual facts and judicial admission now, a judicial admission from the judge himself. So we're not talking about hearsay to support this. So let me just kind of break this down. So the contempt scheduling hearing, which was this week, was before Judge Miller and Craig Wright appeared on video, and then Jonathan Hoff, King's Counsel, appeared in person. And it was about scheduling the contempt hearing against Craig Wright. Now, at the hearing, the judge, he admitted that he had met with, first of all, he admitted, now this is the transcript I read. Whether this is the exact word he used, I don't know. All right, don't know. But he admitted on the transcript that I read that he went to a COPA event. That's what I read. That's how I reported it. That's what I read. Now, if that's what the judge said, which I wasn't there in person to witness exactly what he said, I haven't read the official transcript, nor will I probably ever be privy to it. But what I read on the transcript from the reporter, which was Mr. Pierce, who is a very credible reporter. He's an Esquire, an attorney, and he has credibility and as an officer of the court, so I trusted what he wrote, which he said it was a COPA event. The Judge Miller said he went to a COPA event. Now, COPA is one of the parties in the case. And at the event, he did speak about the case at the event. In fact, Mr. Pierce was reporting it. Now, speaking about the case, it opened up a Pandora's box. Okay, he went to an event. It was a COPA event. Okay, let's just put that aside. Maybe that was okay. But then when he spoke about the case at the event and talked about it openly, what did he talk about? It doesn't matter. It doesn't matter if it was it makes no difference. The only thing the judge would have been allowed to do is said, I'm not allowed to talk about this case. That's what he was allowed to say. That's it. I'm not allowed to discuss this case. I'm sorry. Thank you very much. That's the only thing he would have been allowed to say. He's not allowed to say, I'll only talk about certain parts of the case when the case is going to be done and how it's going. It's going pretty good. What else did he say? There's a ruling that came out yesterday in the Court of Appeal decision where they denied Craig Wright's petition to be Satoshi Nakamoto, and only 4 things were decided. Now, it was one, the judge had to decide a single question. Is Craig Wright, as he claims to be, the person who adopted a pseudonym, Satoshi Nakamoto, who wrote and published the first version of the Bitcoin white paper in 2008, who wrote and released the first version of the Bitcoin source code, and who created the Bitcoin system? This is a pure question of fact. That's all that was decided. That's it. Nothing else. It would be improper. It would be misinformation. It would be potential setting anyone up for liability to say that something else was decided in that ruling other than those 4 things. I see a lot of people who have interest in other things, and they mention the word fraud. That is absolutely inappropriate. If fraud was decided, then you show it to me, and I would say, it was decided. I would report it and I would read it. But there was never a cause of action for fraud. So it would be inappropriate for someone to say anything about fraud, because that's it's slanderous, to say that about somebody when it hasn't happened. So be mindful of that. Whether you hate Craig or not, it's important to not expose liability, because when somebody talks about things that aren't true, it can create liability and it can create exposure. And so don't, just be mindful of that. Even if you're hiding on a Twitter post, don't think that someone like myself can't quickly subpoena that information, from my friend over there in Texas. I can quickly get that in a subpoena. So don't think that that you're hiding. Anyways, let me go ahead and continue on with what happened here on this. So so basically, there's a case that was at Porter versus Miguel, 2001, UK HL 67, and it opened up a test for what's called a fair-minded informal observer test. So we're not talking about actual bias. We're not talking about provable bias or corruption. None of those things are on the table. We're just talking about what's called the standards of what a fair-minded, informed observer would think. Would they conclude the real possibility of bias? That's it. Not bias, not corruption. Just a possibility. And so three real issues stand out. One, the ex-party communication of Miller with one of the party's attorneys, esquires. Is Mr. Pierce one of the esquire for COPA? It sure appears that way. And I wish he would have told me that when he came on my show multiple times. Would have been probably better disclosure. I didn't realize that he was their attorney. Now, was he representing him in the COPA trial? I don't know. But representing him in another capacity? Looks that way. Sure looks that way. He hasn't come out and said otherwise. So it's kind of implied. And the information that I've seen from, people who's doing research online, it appears that way. So he was representing COPA. Now, so in another capacity. Now, therefore, he goes to an event, and the event was a social event, which also now, according to Miller's judicial admission now on Friday, it was hearsay before, it was speculation before, that's why I didn't bring it up. But now that Miller's admitted it, he says, yes, I did go to that event. Yes, it was a COPA event. And yes, I talked about the case. That's it, man. In my opinion, that's it. At that point, Now the Court of Appeal judge, he says that's not a big deal. He says even if he talked about the case, it was after he made his verbal ruling saying it wasn't Satoshi, but before his written judgment. How does that make any sense? The written judgment wasn't done yet. The actual written judgment making a final determination, which could have changed between oral decision and written judgment. 100%. It could have changed. He had, 20 days, all this time to write it. So how does it make any sense to say, well, because the written judgment wasn't out yet, it was okay. This is the Court of Appeals decision yesterday to say that, it was okay for him to talk about the case and meet with one of the meet at an event, a social event put on by potentially one of the parties, and talk to one of the parties' esquires. That's okay. Hello, dude. Okay. I mean, again, I'm not talking about actual bias. I forget that. Actual bias is going to have to be proved, and that's hard to do. I'm not talking about actual corruption. I'm just talking about the standard in Porter versus McGill, which is a fair-minded person, informed observer, may conclude there's a real possibility of bias. All right? And now that it looks like, I think, 260 to 300 people have already signed that petition. It's at change.org. You can find it. I'll put it in the description of this below. You can check it out and sign it. I just signed it myself. I did a little 30-second video on it. And, I have no interest. I have no skin in the game. So I'm not paid by Craig, Wright, or paid by COPA. I have no skin in the game. But I do have a duty to kind of report and see things the way I see them. And I've been doing the best I can to stay neutral in the case and the position as I see things. But now at this point, where, in my opinion, there is a real possibility of bias and an unfair advantage. Put it this way. Let's say that Craig Wright had an event. In fact, there was an event it was a conference. Craig Wright didn't go, but anyways, there was an event going on in UK shortly thereafter, the day after the decision. Actually, the day after the decision came out, it officially started. Now, let's say that the decision hadn't come out yet, and Judge Miller came to the event, and he was speaking there at the event, and Craig Wright was there, And he and Craig Wright were talking about the case. Let's not say Craig Wright. Let's say one of Craig Wright's representatives was there. Maybe not even an attorney. One of Craig Wright's representatives were there, and he was talking to Judge Miller, and then Judge Miller talked about the case. What did he talk about? Does it matter? He talked about the case at an event put on by Craig Wright. Would COPA have a problem with that? Think about it. COPA would raise hell would freeze over. They would bring their entire military army in and pound that court with papers, litigation. It would be like hell on earth over there. Okay, it would be literally, they would come in there and yell and scream. They would lose their mind if that happened. That's how inappropriate that is. So I just want you to kind of frame it in the standards of where we're at. Now again, that this kind of came out on my show. Now, Mr. Pierce has stopped communicating with me. You know, he and I had a good relationship. I had no objections to him, but now he says we're not communicating anymore. So fine. He's now threatened. He's threatened action on one of the guys, 369 BSP Scott, and done a background check on Scott, in my opinion, abusing his legal power in doing a background check on him, because I know very well that Esquires, they have access to LexisNexis, and you can pull people's socials, you can pull people's background checks, all that stuff, no problem. And that's just as an officer of the court, you have a duty to keep that confidential. Now, because of what Scott did, exercising his free speech, saying change.org, he believes that this is bias, and everybody who thinks it is, please sign this petition. He said that he's going to go to the local police potentially, and saying it's harassment. I object to that, dude. I object to that. You know, first of all, I looked at the elements of harassment. Harassment require like sexual advances, racial slurs, personal attacks, like actual, fraud, calling them fraud like people do to Craig Wright. These are harassing things. Saying that I'd like to have an investigation done over a judicial proceeding, that's called freedom of the press. That's just called exercising freedom of the press. And I read the thing. I could read it. Everybody could read through it. There's no elements of any personal vendetta or personal reasons to Mr. Pierce at all, at all. So I think it's a huge abuse of discretion on Mr. Pierce's part to go out there and attack, threaten criminally. Now, when you threaten someone criminally, we have a law out there, and it's called extortion. Because if you're just a regular person out there and an attorney goes and threatens you, he says, hey, I'm going to put you in jail if you don't pay me money or if you don't do something, that's called extortion. You have the right to arrest the person if they've committed a crime. That is a right. And let the magistrate deal with that. That's out here it's a penal code, I think it's 800. Anyways, there's a right for that. But there's no right for me to call you or another person and say, hey, if you don't take that post down off the internet, I'm going to put you in jail. Like, what? You don't have the right to do that. They're like, you're going to call the police on me? Either the police are called and the person's getting arrested, okay, or not. We don't have the right to threaten people with what's called legal process. Now, if it's civil process, that's different. Civil process is, hey, cease and desist, let's meet and confer, let's settle this matter. That's different. But criminal process is not, just the people, and even an Esquire like Mr. Pierce doesn't have the right to do that, dude. I completely object. And I don't care what they say about UK law, how it's different. He don't have the right, man. No, that's just not how it works. So I know that it's a good tactic for bullying, to try to bully the people. But guess what? The people freaking woke up, dude. The people woke up. People ain't scared anymore. People are here to fight back and to rise up, because we're here to just exercise free speech peacefully, and whatever we want to discuss peacefully and come together harmoniously, the First Amendment, the Bill of Human Rights itself protects. So sign the petition. I would recommend it, everybody. Change.org. I'll put a link below. You can check it out. And ultimately, there is a remedy here for Dr. Wright, which he could follow on this. If he believes there is actual bias, that's applying to the court for a disqualification of Miller and getting another judge to hear the contempt matter. COPA's opened the whole box up again on this contempt matter on the grounds that I mean, if COPA sees this video, they should withdraw the contempt motion immediately. If they have any brains in their head. I know they won't do that, so that's why I'm telling you that, because they suffer from what's called arrogance. But, if they had actual strategy behind them and they cared more about winning than they did about whatever principle they're on, they would withdraw the contempt motion immediately and settle the case, basically put the case to bed, because by having the contempt motion pending, it's opened up the jurisdiction to the trial court. The Court of Appeal has denied the Wright's appeal. The trial court's got the jurisdiction back again, and so now Wright's going back into the trial court level, and they're going to hear the contempt matter, and he has the right to make a challenge, to make a motion. And now that the new fact has come out about this judicial admission, and it's not just Wright or me or anybody, it's like over almost 300 people have said, well, I was a witness to that, or I'm a reasonable observer outside, and I'm seeing this, and it just doesn't look right to me. I want somebody to investigate this at the Queen's High Court. I mean, people are saying that not because it's just a neutral observers. These are what are called reasonable people, informed observers. Now, COPA, once Dr. Wright makes that sort of challenge, he applies to the court for disqualification. Well, then COPA has the right to oppose that, and they can say, well, we got 300 people all show, and they say that that's not, and here's why. They have that right, dude. And well, they have a right to do that, but again, it's not. That's only if Judge Miller decides not to recuse. I mean, what's likely going to happen is Wright will go and apply to the court. Judge Miller will not recuse himself. He will say, no, hell no, I'm not getting off this bench. That's usually what happens. In my experience, I've done this before, and so in my own cases, I really could have some fun telling stories about that. I could even share audios of that. I got the audios. I got the transcripts. Actually, a good laugh. If we should have some time on a video or maybe a live about that. Anyways, so in this case, Judge Miller won't recuse most likely because it would upset the entire court case. It would basically overturn all of his decisions, and they'd have to restart the court case over. Trial would have to be redone. COPA would have to do the whole thing. It would upset everything. But again, that's not the people's problem. The people's problem is that why was he having ex-party communication with one of the party's counsel at a sponsored event by one of the parties? Or at least appears to be that way because he's admitted it now. It's not hearsay. It's not all the internet. We did see the photos on the internet of the judge and the attorney talking together. We saw that. That's on the petition. So, wow, that's them talking at the event? And the judge now has admitted talking to them at the event. So it's no longer like, oh, that was a different event. No, it's come out. He admitted it on the record. He doesn't think it's a big deal, okay? But Her Majesty's Court, it has a reputation to keep. It has a high standard of integrity to keep because the people, they bring these actions to the civil court in hopes that they're going to get some sort of justice. But when the people see that, you just go to the court and it's just a bunch of attorneys meeting at these events and the judges, they all rub elbows together and they talk about the case at these events. What kind of nonsense is this type of court? How is this a judicial system? Her Majesty's Court? It's supposed to have a high esteem of integrity and the best court in the world, high court. Dude, Miller, recuse yourself. Otherwise, get a judge to make a decision on the disqualification itself. That's my plea. That's my motion as a non-lawyer from out here in California with absolutely no skin in the game and no interest in this, other than just an informed observer wanting to see a little bit of reasonableness in a case, even if it's just an appearance of justice and there isn't just us. I'd like to see the appearance of it. And it sure as hell don't look like that anymore. Not even close. Having ex-party communication at the social event put on by one of the parties, and then the judge now refusing to recuse himself. And I mean, there's a lot of other issues that come up. I mean, the whole disability thing with Craig Wright, them laughing about that, saying that's not a big deal. Him just not getting treated in any different role. That's a really big deal out here in America. You can't just steamroll people who have a disability. You actually have to give them very, very extreme liberal, reasonable accommodation. So that's a whole nother issue. But this whole issue of bias is serious. So hit the like button. All right, subscribe. My name's Gavin Gregory. All right. And I signed Gavin Mail. It's my legal name. And I also put a comment below. All right. Sign the petition. I'll see you at the top. Later.